calling 2025 CR 008801, State versus Kimberly Quavas. Could I have parties announced?
Rick Pena for the state of Texas.
Jorge Canales for Ms. Quavas.
And are you Ms. Quavas?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
I have it, and I have it.
Court will find that the state is in compliance with discovery. Ms. Quavas, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Huh? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, yeah.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Ms. Quavas, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with injury to a child, elderly, or disabled person, bodily injury as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, sir.
Ms. Cuevas, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 2025 PF 09696. There's an affirmative finding of family violence. There's to be no contact with Evelyn Reyna and Robert Reyna. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Correct.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? All right, do you want to discuss that with your client?
Yes, Your Honor.
Mitchell.
Your Honor, my client is going through a divorce proceedings, and she was trying to get primary custody of her child. And I believe
Both my kids.
both children,
Oh, I have nothing to do with what they do on the civil side.
it has to be addressed in the civil side.
I won't be able to have sole custody, but can.
So here's the thing. I don't know what they will do with your case on the civil side. All I can tell you is legally, with an affirmative finding of family violence, we can go off the record. Here's the thing. If there's a custody issue that's going on the civil side, if opposing counsel sees somebody has an affirmative finding of family violence, that makes their case easier, depending on what's going on. What I can tell you is all things equal. If one person has an affirmative finding of family violence and the other person doesn't, then the court is supposed to take note of that. And that person who has the affirmative finding of family violence, they're not supposed to be designated as primary custodial parent. You want to discuss it with
Yes,
your
yes.
attorney? All right, I'll have you all sit back. All right, the court is back on the record in 2025 CR 008801, State versus Kimberly Quavas. All right. And Ms. Quavas, where we stopped, the court was giving you the consequences of an affirmative finding of family violence. And it appeared you need to discuss that with your attorney. Have you had a chance to discuss that with your attorney?
Yes, sir.
All right. And counsel, does she have a civil attorney?
She does.
Does she need to discuss this with her civil?
All right, folks, pause here that. Affirmative finding of family violence is huge. It can impact not just criminal sentencing, but also custody battles and even gun ownership. If you're watching as a parent, pay attention. This is exactly why courts take these findings so seriously.
Attorney, before we continue,
I would like to, but I don't think that I'd get a hold of him right away.
well, what we can do, if there's no objections, we can recall this for Thursday.
Okay, yes, I'd like to talk to him.
All right, we'll bring you back on Thursday. Okay? Once you sign the reset form, you're excused.
Thank you.
You're welcome. Court is calling 2025 CR 003-006, State versus Chase Anthony Lopez. Can I have parties announced for the record?
Melissa Alpin for the state.
Caitlin Knowles for Mr. Lopez.
And are you Chase Lopez?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lopez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Lopez, did you review the court's admonishments with your attorney? Did you understand it, sign it in all the appropriate places?
Yes, ma'am.
You're charged with collision involving injury as a Class A misdemeanor. At least that's how the state is proceeding. The range of punishment for that is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. All right, off the record. So is this an application?
Yes, Your Honor, for deferred adjudication.
Okay, I don't have an application.
But I don't want to fill it out unless it's.
Okay, let me see. Maybe it's stuck to or stapled. Okay, just 1 second. It's stapled to the acknowledgement of discovery. All right. Thank you. No. Did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it? Do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
You're going to need to speak up.
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to a year in the Bexar County Jail and up to a $4,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering into a plea, you could be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a $1,500 fine, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 80 hours of community service restitution, no contact with Aaron Dabney and Skylar Henderson, MRT, no alcohol. What is this? Alcohol consumption. If you're placed on probation, you're not allowed to drink alcohol at all. You understand? ETG and regular UAs and the driver's safety course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers and evidence states.
Quick reality check. Even in criminal cases, there's overlap. With civil issues here, Kimberly's custody battle is hanging in the balance, and any prior findings of family violence could tip the scales against her audience question, would you risk a plea knowing it? Might affect your kid's custody.
Exhibit 1 with its attachments? No objection, Your Honor.
And State, is there going to be any requested restitution or
There
not?
was not, Your Honor. The victim did not have any.
All right, State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, we're going to waive any PSI, but we did have a couple things that we'd like to bring to the attention of the court.
Yes.
With regard to community service. My client works over 60 hours a week. He just got promoted to supervisor. He's going to do everything that he can to keep his nose clean during probation. We're asking that you probate at least some of the community service. And then I don't believe he's a great candidate for MRT. MRT is for those who have a series of bad decisions and how it affects their loved ones and how they can turn it around. My client, as you read in State's Exhibit 1, literally was just disoriented and scared at the time of this offense. I don't believe that perhaps the court would like to revisit that at another time. That's fine too, but we're asking the court to remove the MRT and at least probate some of that community service, Your Honor.
All right, why did you leave the scene?
To be honest with you, I don't know.
I'm sorry, what?
I don't know, ma'am.
I mean, well, it says in the police report that your mother convinced you to go back. How old are you?
28.
28?
Oh, I'm sorry, 29.
29. So you were probably 28 when this happened?
Yes, ma'am. That was,
So why did you leave the scene?
I don't know. Panic. Really all I could say.
I mean, I could see this if you're a teenager, okay, panic. If you would have stayed at the scene, this is just an accident.
Yeah.
It's not a crime. So I don't understand why you would leave.
I was exhausted. I've been doing this type of work for over 2 years now.
What type of work?
I am a foreman for a construction site. We do fiber optic cabling for data centers. It's a lot of stress involved. Timelines get pushed forward. A lot of stress is on that. At the time I was working night shift, same as right now. I got like 2 hours of sleep before I came here. I'm used to running on eve a lot of the time, and it caught up with me. That's what happened.
Right, but you do understand that the fact that you are tired, the fact that you work night shift has no bearing on not stopping to check on somebody to see if they were injured from an accident.
Moment of impact to the time of me getting in the cruiser with the cop. I had just gotten in the impact. I fell asleep behind the wheel. As far as between that moment and me getting in the cruiser, honestly, as disoriented as I was, I couldn't tell you what my thought process was.
This
I mean, but you-
deployed, and he has diagnosed anxiety as well too. So that
Well, maybe he shouldn't be driving, because here's the thing. You knew enough and your mom knew enough to say, hey, you need to go back to the scene of the accident. So unless your mom is clairvoyant, she knew. You told her, hey, I'm in an accident. Or she said, hey, what happened to your vehicle? And you told her you were in an accident, and you had to have told her the location, because how else would she know to tell you to go back to the scene of the accident? So I don't know if you should be driving. So tell me why you should be driving.
It's the only way that I'm able to get to work. I've had no accidents before this. As I said, I was exhausted and I fell asleep behind the wheel. As far as the cause of the accident, that's what it was.
Well, see, here's the thing. The big issue, honestly, is not the fact that you had an accident. That's why people have car insurance, because you may have an accident.
I should have stayed after.
Yeah.
It's plain and simple.
And the reason why I'm asking you these questions, because I'm trying to see if MRT is appropriate for you or not.
would you tell the court about some of the things that you've done since the accident that to demonstrate to the court that you understand the mistakes that you've made and changes that you've made in order to better understand and get along in society without being reckless or neglecting others?
Here's a courtroom nugget: the judge can't just ignore prior findings of family violence when it comes to custody. Even if the divorce case is separate, these facts essentially act as legal leverage. It's like a shadow following you into every civil proceeding.
As I've gotten promoted recently, trying to build a community and working with coworkers and understanding the trials and issues that my other coworkers have. I try and work with people and understand them on a deeper level. And right now that's what I'm working on, is my leadership skills and leading by example. And right now, that is not something that I want anyone else that I lead to do, let alone myself. That is not something that should happen.
Probation with regards to MRT. Do you think that's appropriate in this case?
So why don't we hold it in abeyance for now?
Okay. Thank you. There's going to be 2 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, or you can do the patch. The patch costs more, but it'll allow you to be at your work. With the patch, they'll put it on you. You're not allowed to remove it. They'll remove it when they'll give you a date to come in to have it removed. Field visits 1 time per month for 2 months. Proof of employment within 40 days. No employment as a home health care provider or with minors. And my understanding, Ms. Abrams, there's no restitution that is due.
That's correct.
All right. There's going to be the driver safety course. 80 hours of community service restitution. With regards to the 80 hours of community service restitution, you will either do those 80 hours or either you can write a letter to the complainant in this case expressing your dismay and expressing your apology to that person. You understand?
Let's do that.
And I'll take it and give it to you because you're the government contact. Okay.
Okay, and that's to be 80 hours community service restitution, other letter to Aaron Dabney. State, with regards to this no contact order, I don't know how he does that when people are driving on the road. He's not going to know if the person.
Yeah.
So I'm not inclined to issue a no contact order.
That's fine. I don't believe they have any personal knowledge of or personal relationships with each other. Obviously, this was a car crash, so I don't think it was coincidental or anything that they knew each other. That's just, standard recommendations.
All right, thank you.
That's fine.
Probation, does he need the driver safety course?
Yes, Judge.
All right, and then the driver safety course.
Said the driver safety course.
Oh, thank you.
Do you want the MRT holding a hand?
No. Is there anything else, probation?
No, Judge.
Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Accidents are accidents, and they're called accidents for a reason. A lot of times, if people would just stay, even if you have an accident and you don't have any insurance, don't leave, because then guess what? Now you got an issue with not having insurance and you have a felony charge. You understand?
Yes, ma'am.
All right, once you go over conditions with probation, you're excused. Good luck to you.
Thank you, Your Honor.
Thank you.
Heads up, this is a classic plea warning. The court isn't bound by your plea deal, so even if you thought you'd get a lighter sentence, the judge could decide otherwise. Always double check your legal options. And yes, you can withdraw the plea if it backfires. This is why having an attorney you trust is critical. Drama alert: the court is zeroing in on personal responsibility. It doesn't matter that he was tired or exhausted. The expectation is that you stop and render aid. Audience question: do you think the stress of work excuses reckless behavior? This is a gray area in negligence law.